Welcome to Collier County Court. I'm Judge Martin. Are you hearing me okay?
Yes, Your Honor.
Good, good. Good morning. We've got one matter set for the 10 a.m. docket, which is Gerber versus Thomas and National. Can I get counsel's appearance for plaintiff, please?
Yes, good morning, Your Honor. Steve Simon on behalf of the Gerbers.
Okay, Mr. Simon. And is it the same counsel for both Thomas and National?
Yes, William Pereira on behalf of the defendants.
Can you spell your last name, please?
Yes, Your Honor. P as in Peter, E-R-E-I-R-A.
Okay, Pereira. Got it. Let me volume up a little bit. Okay. All right, Mr. Pereira. And actually, Mr. Simon, this is your motion. It's plaintiff's motion to dismiss the counterclaim, correct?
That is correct, Your Honor.
Okay, I'll invite you to proceed.
Okay, thank you very much. Yes, Your Honor, this is a Hurricane Irma claim. At least the Gerbers started out as a Hurricane Irma claim, just to give you some background. And the Gerbers, back in January 2018, hired Mr. Thomas and National Adjusters as their public adjuster. Apparently, Mr. Thomas invoked appraisal and appointed himself as the appraiser for the Gerbers, and it was proceeding in the appraisal process. In April of 2018, Mr. Thomas felt that he was going to get a zero recovery on behalf of the Gerbers, and he withdrew from the appraisal process. And thereafter, another public adjuster got involved on behalf of the Gerbers, and ultimately I got involved on behalf of the Gerbers, and Mr. Thomas and National Adjusters were terminated. And in November of 2020, I actually resolved the claim on behalf of the Gerbers with their insurance company. And all of that are factual based, and it's just a predicate for why we're here today. The motion to dismiss the counterclaim and the affirmative defense are based on the contract, Your Honor, which we attached to our original complaint. And essentially what our position is that the contract allows National Adjusters 10% of the entire amount of the proceeds collected for the loss. Collected being the key word. There's nothing in the contract that says that it's collected by someone else. The logical interpretation of the people is that has to be collected by Mr. Thomas and or National Adjusters. And if there's some type of ambiguity as far as them arguing something else, then of course that is a question of law for the court. And so and in the counterclaim in paragraph 7, they allege that the settlement, that it was unknown to the counter plaintiffs that the counter defendants resolved the claim or loss with the insurance company. So clearly, Your Honor, they have alleged that they had absolutely nothing to do with the settlement and or monies collected. They didn't do it. And so our position is they don't have a right to a fee. Their contract is clear and states that it must be proceeds collected. Obviously, the interpretation is by them, not by anyone. And that's consistent with Florida Statute 626.85410A, the public adjuster statute, that specifically states in section 10A, that the charge, compensation, payment, commission, fee, or anything of value must be based only on the claim, payment, or settlement obtained through the work of the public adjuster. That's what it says, Your Honor. Through the work of the public adjuster. Their contract, it has to be based on that and interpreted based on this statute. Obviously, they have alleged in paragraph 7 of the counterclaim that they didn't do any work that resulted in the collection of this money. And quite frankly, for 2.5 years, they did absolutely nothing. But legally, Your Honor, their contract only entitles them to a percentage of money they collected. They didn't collect any money. They're not entitled to a fee here. and we're asking that their counterclaim and affirmative defenses that assert that they are be dismissed.
Okay, Mr. Pereira, your response.
Good morning, Your Honor. So what's essentially happening here is the plaintiffs are asking the court to treat this motion to dismiss as a motion for summary judgment. And they're trying to use basically a laundry list of facts that are still in contention right now, including whether the plaintiffs terminated the defendant in November prior to a resolution of the Hurricane Irma claim, whether the contract between the plaintiffs and the defendant requires of 10% of the settlement proceeds to the defendant only if the defendants collect the proceeds from the settlement, whether the contract between the plaintiff and the defendant requires the defendant perform as an independent and unbiased appraiser in the appraisal process between the plaintiffs and their insurance company, whether the defendants performed any work on the plaintiffs in behalf or in regard to the Hurricane Irma claim that requires the payment of the defendants under Florida Fee Statute 626.85410A. Whether the defendants did any work that resulted in the settlement issue, whether the defendants withdrew from the representation of the plaintiff in regard to the Hurricane Irma claim, and whether the defendants' work on behalf of the plaintiff resulted in zero work for the plaintiff's insurance company. These are all contentious facts that are not appropriate to be, argued right now in a motion to dismiss. This is much more appropriate for a vehicle like motion for summary judgment. And so we ask the court, because these facts are still in contention, to deny their motion to dismiss.
Okay, Mr. Simon, I'll allow you a brief response.
Yes, very briefly, Your Honor. A lot of those facts are disputed issues, and that's not the basis for my motion. My motion is their contract, which is part of our complaint, which is appropriate for this court to review and include in the decision, says 10% of monies collected. And clearly in their counterclaim in paragraph 7, they have alleged that they had no knowledge of the settlement. So clearly they didn't do anything to collect this money. And consistent with Florida statute 626.85410A, where you have to have your work resulting in monies collected to charge a fee, they didn't do that. These are not disputed factual issues. This is based on the allegations of the counterclaim and the contract itself. So it is appropriate for this court to grant this motion.
So it's really a 3-point argument then. The contract just says proceeds collected. The contract does not limit itself to proceeds collected as a result of the effort of the adjuster. Just proceeds collected, that's pretty wide open. You're bootstrapping that with their own allegation that the collection was done without their knowledge, and then that the statute would require the collection to be as a result of their effort. Do I have that right?
That's correct, Your Honor.
Let me just take a quick look. I have the statute up in front of me. I want to read this paragraph 10A. Just getting through the initial clause. If a public adjuster enters into a contract with an insured or claimant to reopen a claim or file a supplemental claim that seeks additional payments for a claim that had previously been paid in part or in full or settled by the insurer, is that the scenario that we're in? Does this paragraph apply?
I believe the paragraph applies, Your Honor, but no, that particular provision doesn't apply. It's after that where it talks about the charge that they can charge.
But am I to pull that second half of that paragraph out of the context of the first half? It seems to limit it to applying only on reopens and supplementals.
I see what Your Honor's talking about, and if you bear with me a second, I think Your Honor, what I believe is that what they've said there would apply not just to, it would apply to any, there would be no logic in having this just apply to supplementals. I believe that the intent and the purpose of that, the second half of that paragraph, is that the fee, whether it be the initial claim or a supplemental claim, must be based on the work that they did. I mean, to interpret it that somehow that wouldn't apply to an original claim, but would apply to a supplemental claim, just is not a logical interpretation. So I agree, it's not the most clearly, laid out for the statute, but it just common sense would say it has to apply to everything.
It sure is tucked away in the middle of 10A. If it's something that governs the payment of a public adjuster, I mean, this is the section on public adjusters. They definitely took it out of easy view. Charge, compensation, payment, commission, fee, or any other thing of value must be based only on the claim payments or settlement obtained through the work of the public adjuster after entering into the contract. And again, the next clause, compensation for the reopened or supplemental claim, blah, 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 blah. All right. Well, I think that it's certainly an interesting point. I see where both sides are coming from with this. I think ultimately, I can't quite find my way to plaintiff's counsel's argument here, although I do see where it grows legs, but I can't quite read 10A to govern all payments to all adjusters under contracts like these. And so I'm inclined to be persuaded mainly by defendant's argument that procedurally we're a little bit ahead of ourselves here. This may well be meritorious, but I think the vehicle will be summary judgment. And so I'm going to deny the motion to dismiss, anticipate that I may hear something like this again in the relatively near future. Let's just do a real quick down and dirty case management here. First, Mr. Simon, how much time will you need to answer the counterclaim now that the motion to dismiss is denied?
I can do that in 10 days, Your Honor, if that's okay.
Okay. And then let me stay with you for a minute, Mr. Simon, and then I'll touch base with Mr. Pereira. As you all probably know, the Supreme Court has pushed all of us, including county courts, into case management. And so my goal will be taking all of my cases, even the 1,400 or so that are existing, and getting them scheduled. And so I can do a few different things. This case is relatively new. I can ask you all to come up with an agreed case management plan and take it from there, or I could put you on to a motion docket in 60, 90 days if we think that's expeditious. Do you have a sense, Mr. Simon, as to what the court can best do to facilitate things here?
Well, may I ask one question, Your Honor? And is there, I know in circuit courts, there's typically an 18-month trial. I'm just not sure in county court how the timing on that.
Sure, good question. County court, what we have done with the differentiated case management is we have defaulted to expedited. So all the county court cases, unless or until the parties move the court to find otherwise, we'll set them up as expedited and we'll aim for a 12-month resolution. And so this case is a little over 90 days old, relatively new, and obviously everybody's been diligent. There's already been a lot of activity. So I'm happy to, I'm not going to come down like a ton of bricks on a 90-day-old case. What the case management plan would require you to do, if you all filed May 1st instead of February 1st, once I saw that service had been achieved, I'd be setting you for something 9-10 months out to pre-try the case and get onto a trial docket. And then I might see you at various points along the way. So a case management plan from here maybe about a 180-day plan to get the case to a pretrial conference posture where we could set it, which would mean that you all would have discovery and ideally mediation done prior to about 180 days from now. I don't know how realistic you might feel that is, and that's why I wanted to just take a moment and have a conversation with you. I'm going to let my next hearing into the courtroom. They can hang on for a minute. What do you think, Mr. Simon? Do you have a sense on that?
I think we can. I think we can accomplish it, Your Honor. I mean, obviously, you know, I'm going to take Mr. Thomas's deposition, get some documents from him, and I'm going to come back on a summary judgment. So,
okay. And Mr. Pereira, what's your sense on that? How can the court best facilitate timely resolution from your standpoint?
Your Honor, so the 180 days works. I will admit I am the lower man on the totem pole around here, so I don't fully want to commit, you know, to anything. I think we can talk to opposing counsel and sort of figure out a good case management plan, though.
Okay. Why don't I do this? Getting back to the motion, I thank my 1015 for just a moment of patience here. So I've denied the motion to dismiss the counterclaim. Plaintiff will have 10 days to answer. And then why don't I could say 30 days to submit an agreed case management plan. The form of that is on our 20th Judicial Circuit website, and you all could pull that. The standard county court case management plan is right there, and you all may just want to tweak it slightly to suit yourselves. And then if I could ask that you get that submitted to me with a proposed order that adopts it, then that will keep us in touch with each other, and that will trigger me to just kind of figure out what my schedule is going to be. I may very well see you back for summary judgment before anything gets too red hot, but that way we don't lose track of the situation. Does that sound okay, Mr. Pereira?
Sounds great, Your Honor. Thank you.
Mr. Simon, sound okay?
yes, very good, Your Honor.
Okay, contact my judicial assistant if you have any difficulty finding that standard plan or any troubles with any of that, but I'll look to receive the plan with the, you know, as you know, just a little paragraph at the bottom, which is the order for the court to sign off and ratify it. And then I think we'll be up and running and in good shape. And again, I thank you for the diligence you both have already shown. I think we'll try to work this to a prompt resolution for the parties.
Okay. Thank you very much, Your Honor. Have
Thank
a
you,
great
Your
day.
Honor.
Okay, and I'll ask Mr. I could do it either way. Mr. Pereira, you prevailed on the motion. Do you want to do the order that denies the motion to dismiss for us?
Yes, Your Honor.
Okay. And let me just make sure one more time. Pereira.
Pereira.
Got it. I think
I
I
have
have.
to spell it
Okay.
out, or else I won't remember.
You can change your name on Zoom. For judges like me, it may be helpful because I do heavily rely on that. Okay, gentlemen, I'll let you get back to work. Thank you both and stay well.
Thank you. You too, Your Honor.
Thank you. You too, Your Honor.
Okay, that'll bring us to our 10:15 hearing, and thank you for being patient for just a few minutes. LMCU versus Garcia. Can I get counsel's appearance for LMCU?
My apologies, Your Honor. Good morning. My name is Nicholas Merriweather. I am here on behalf of the plaintiff.
Okay, Mr. Merriweather, good morning. And for the defense?
Your Honor, good morning. Gabriel Veliz for the defendant.
Okay, good morning to you both. This is plaintiff's motion for summary judgment, and Mr. Veliz, hang on just one second. Okay. Just reviewing my notes from Friday, it's amazing how 2 days away from the office, it feels like I haven't looked at it before. So Mr. Veliz has raised an arbitration question that's not really set for today, but I did make a note of it because I thought it may inform our discussion. Mr. Merriweather, you'd filed for summary judgment and Mr. Veliz has filed for arbitration. Do you agree on the arbitration, or do you wish to argue that the court should consider the summary judgment today? how does plaintiff want to proceed at this point?
Your Honor, this time, because nothing has been discussed with us or no offers have been made, and I don't know where he's getting the entitlement to arbitration, I would request that unless he has filed a hearing on that we just proceed forward with the summary judgment motion today.
Okay. All right. Mr. Valise, it looked like it's just May 2nd that you filed the motion to compel arbitration. Are you in conversations with my assistant to get that set, or have you not yet tried to set that?
Your Honor, I have not yet tried to set that. With respect to what counsel for the plaintiff just mentioned, with respect to entitlement, I believe I would have to get on the horn with the plaintiff, because to establish entitlement, I believe there are some documents that were signed between the parties that is not in the current point in the complaint, the contract. It's not in the current contract where the entitlement to arbitration would be. So I was just trying to figure out if I had to do a little bit of further discovery to establish entitlement before setting the matter for hearing.
Well, because there is a contract attached to the complaint, account and services application, which appears to have quite a few pages of tiny print. So I will confess I've not read all of it, but I was hopeful, Mr. Valise, that if you had filed that motion, it meant that you had located somewhere in the tiny print an entitlement. You're indicating you can't point me to that yet, because by my analysis, that potentially would be a genuine issue material fact that would preclude finding as a matter of law that judgment's appropriate. But you're unable to point me to that?
Your Honor, that is correct. With respect to the contract itself, it does not specifically, I'm sorry, let me rephrase that. With respect to the contract that is attached, but upon information and belief, there is a separate provision of rights that I believe is incorporated through the contract that potentially gives the ability for arbitration. So unfortunately, I can't support more than that with respect to the title of arbitration.
I do see, for example, reference to a membership agreement in the contract. So I don't know if that sort of document potentially contains that. Mr. Merriweather, well, let me ask this of Mr. Valise first. Outside of the suggestion that you have an entitlement to arbitration, do you take any other issue with the motion for summary judgment?
Your Honor, I don't believe so. My motion for arbitration, I was going to tie that into the allegations in the complaint that the plaintiff has complied with all conditions precedent, or that my client had waived any sort of requisite condition precedent being met by the plaintiff. So to answer Your Honor's question, other than the paragraph alleging all conditions precedent have been met, or that my client has taken any action to waive, I don't believe I have any other issue with the motion that the plaintiff is seeking.
Okay. Well, Mr. Merriweather, why don't I do this? Why don't I let you proceed to make the argument on the motion, and then potentially what I can do is I can take the matter under advisement briefly to allow Mr. Valise to get these other documents. We may have to create some structure to that, but either that provision's there or it's not, and I'd like to figure that out sooner rather than later. Case has been pending over 6 months, well over 6 months. And so I don't know if there's already been an attempt to get that sort of discovery, but I would potentially grant this motion and resolve this case if there isn't anything there. I understand, I take Mr. Valise's suggestion as a good faith belief that there is support for his position, but that should be something we should be able to sort out relatively quickly. Get copies of the membership agreement. This references credit card agreement, disclosure addendum, and membership agreement in addition to this application. Get those documents, read them, see if there's anything in there. Tell me there is or tell me there isn't, and then I rule. Mr. Merriweather, what are you thinking as far as that sort of overview?
Yes, Your Honor. And candidly, I am looking at my second screen, so that's why my head is turned.
Okay.
But I'm looking at the documents that we attached to our complaint, the original contracts that were signed. Typically, that type of language with regard to arbitration would be somewhere in the events of default and acceleration clause, or they may be a separate paragraph. And just for the court's edification, I'm on page 7 of 9 with regard to the complaint that was filed. I don't see anything that references arbitration being a condition to proceed in. I do know that in the general sense that there are some contracts that may say any type of dispute may be subject to arbitration. That typically has to be done before a lawsuit is filed, but I don't see that language in this particular contract. So Mr. Velez states that he had, upon belief that there was a separate document that is the basis for his request. I don't know what that document is. I don't see it. It wasn't attached. He filed this on the 2nd. He has not moved for any type of discovery. So I would ask that there be a judgment entry because there is no genuine issue that has been raised. And based upon the time between filing the request for arbitration or the demand for arbitration and today, nothing has been done. I don't think anything has been raised to create a genuine issue, particularly because our motion for summary judgment with supporting affidavits were filed January 13th, 2021.
Right.
But I'm still looking just to verify that I'm not speaking incorrectly. I'm trying to read the tiny print myself, but I don't see anything referring to arbitration in any of these documents.
And I just was trying to see, Mr. Velez, how long have you been on this case? You've been on it since the time of the answer? I think so. December?
I've been on it for close to the inception of the case, Your Honor.
Because it is something that I might have expected would have been raised a bit earlier, possibly even in the initial response to the complaint.
Your Honor, with respect to the arbitration issue that was raised, it, as a counsel for the plaintiff has indicated, and I don't dispute that there is not a specific provision within the contract, but in my preparation for a potential defense, it was something that I had to do independent research to see if there was a basis for arbitration. And admittedly, my basis for arbitration is upon information that there's a potential it might exist in the documents that are referenced in the contract but are not added. So it is, upon information. I can't say with certainty, but it's just something that in my research and reading the contract and the fine print is something that came to me as a potential avenue to defend against the claim or resolve the claim, better said.
All right. Well, let me just look at one other thing as far as my notes. Okay. I think what I'd be inclined to do, in really an abundance of caution and fairness, I think that Mr. Merriweather is on solid ground here, but I want to allow a brief period just to ensure that Mr. Velez does not have a viable argument that the parties have already bound themselves to arbitration. It may be a little bit of a lack of diligence on the part of defense counsel, but it's certainly not an offensive or overwhelming lack of diligence that puts us in this position where this is being raised on the eve, basically, of summary judgment. But what I might, I guess a pathway through this is this. I could potentially take the matter under advisement and instruct the parties to exchange that discovery on an expedited basis. It should be pretty easy, Mr. Merriweather. All documents that would govern that account go over to Mr. Valise, and then Mr. Valise has a very short period of time to review them and notify the court if he has found a basis to persist in an argument that there is a binding agreement between these parties that they'll arbitrate before they litigate. If that's not found, then I should grant summary judgment. If it is found, then either I should continue to keep this under advisement while y'all arbitrate, or there may be additional motions Mr. Valise needs to bring. But I'd like to just give you a brief period of time, exchange the documents, look at them, and let's see whether there's anything here, as I don't really want to prejudice Ms. Garcia. If
Your Honor, may I make
I'm
sorry, I'm so sorry.
Go ahead, Mr. Merriweather.
I was gonna say, may I make a suggestion and
Sure.
say that based upon the court's analysis, that we take this under advisement until the 31st, which will be the end of the month. And between that time, plaintiff will release all documents over to the defendant on an expedited matter. I can talk to my client and have them provide us everything. What we will do is we'll file a notice of filing stating that, on this particular date, we provided opposing counsel with documents. If counsel finds that the documents have something that exists, or even if we find something that exists, we will inform the court. But otherwise, if between the time of the notice of filing that we've, in compliance with the court's request and the 31st, and defendant does not find anything that binds us to arbitration, I think thereafter, either the 31st or the 1st, this court can enter a final judgment based upon there being no genuine issue of material fact.
I like that idea. I guess I would just suggest a slight adjustment, but I'm still open to you telling me why my idea is not as good as yours. Don't worry. But perhaps I like the idea of the notice of filing, because then I can see what's happening. But what if I were to, I'll instruct you to do a notice of filing within X days, and then from the notice of filing, Mr. Valise would have Y days to raise something or not, and then the court can track that. And if I don't get a notice of filing in time, then it might just be the simplest for me to deny without prejudice the summary judgment. But as long as the notice of filing is timely, then I wait to see if anything comes from Mr. Valise timely. If not, I would grant summary judgment. And on the other hand, if he raises something, then it may be enough for me to rule. I may have to reset a brief hearing or something like that. But a timeline for plaintiff to perform and a timeline for defendant to perform, both of which should be fairly expedited. Do you have a sense, Mr. Merriweather, as to how quickly you think you'd be able to do a notice of filing with all account documents for this account?
Yes, Your Honor. And I was thinking the same. I just didn't want to bind either of us, because I was thinking maybe we could provide everything by the 21st, which would be this Friday, and then they can file whatever they need in response by the 28th. So that gives us both a week to have the documents at a minimum. By the 31st, the court will either see, if there's something there or there's not. But that would be my request. The only thing is that the staff members who handle this particular client are off today.
Okay.
So I will make sure that they get to it tomorrow. And if I cannot, for whatever reason, get the documents by the 21st, I will inform both the counsel and the court, just so you all are aware. But I'm thinking that we can get everything by the 21st.
Why don't I give you, I know I appreciate that you're working very promptly, but why don't I give both sides a little bit of breathing room and just say 10 days, 10 days.
Okay.
So 10 days to do a notice of filing. If you get it filed in 5 days, that's when Mr. Valise 10-day clock. So it could be a total of 15. Do you follow me?
Yes, ma'am.
Not a
Yes,
total of 20 necessarily, but 10 days to do a notice of filing, and from the notice of filing, 10 days for Mr. Valise to speak or hold his peace.
Yes,
Mr. Valise, does that sound workable for you, just to give you a bona fide chance to explore what may be a meritorious argument And failing that, then the court will rule. And I'll note as an aside, parties are always free to speak and see whether there's any other arrangement that you all want to make. But we'll try to move this to conclusion in no more than 20 days. Sound okay, Mr. Valise?
It sounds very workable, Your Honor. Thank you.
All right. Well, I appreciate you all sort of thinking outside the box with me on that. I want to balance the equities there. So, all right, then I'll note in my minutes that it's under advisement, and plaintiff will do a notice of filing any other account documents that are referenced in the contract that's attached to the complaint. You'll do so within 10 days of today. And then from the date on which the notice of filing and e-service is achieved, then defense will have 10 days to file a document that either notes, directs the court's attention to the provision that you believe defeats summary judgment. You'll probably briefly brief that. And then if not, if I either don't see anything or if defense files something briefly to concede we're not able to find an arbitration provision, then I can rule, and it does appear otherwise the summary judgment is well taken. And likewise, same timeline if y'all want to just try to chat and see if there's any third avenue through this controversy for the parties, that's always fine too.
Okay, Your Honor.
Okay.
Do you want an order, or do you just want to rely on your minutes for that?
I think I'll just do the minutes for the under advisement. I have your final judgment. I've already verified the figures in it are correct.
Okay.
And just quickly, and I appreciate HMAV Cherry's patience for a second. Principal case 1, 6205.80, interest 1, 391.92, late fees 159.20, principal number 2, 4788.20, interest number 2, 260.67, late fee or fee principal number 2 is 150, and then a shared attorney fee of 600 and a shared court costs of 380. Those are the figures I had. I see that for Mr. Valise's benefit. That's what's in the affidavits and in the proposed final judgment on which I'm sitting. And if it ends up being denied, I can do that order. That'll be pretty short and sweet. So nobody will have to draft any orders, just get some legwork done.
All right, sounds good.
Okay, so with that, I'll let you all get back to work and move to the next hearing. Good luck, everybody.
Thank you, Judge. Have a good day.
Thank you. Okay, that'll bring us to HMA v. I believe it was Cherry, although I make sure I have that right. Okay. Can I get counsel's appearance for HMA, please?
Christopher Bidoff for the plaintiff. Good morning, Your Honor.
Good morning. Okay, and I have Ms. Cherry. I'm going to ask her to unmute because I muted her earlier. It was very loud. See if she can hear me. You know what I mean? Okay. Is it Ms. Cherry? Am I saying that correctly?
Yes.
Okay. Good morning.
Good morning.
All right, Ms. Cherry, this is HMA's motion for summary judgment on a lawsuit for medical bills filed on a theory of unjust enrichment. I will note something that I didn't pick up on until I had fully reviewed the file. The complaint sought over $11,000, but ultimately the motion and the affidavits seek a lower amount of $3,422.24. I think the complaint had the pre-adjusted figure, and the judgment and the motion, the proposed judgment that goes with the motion, have a self-pay adjustment that brought it down to $3,400. Am I reading that correctly, Mr. Bidoff?
That's correct, Your Honor. The 3422.24 also includes court costs as well, but there is the 65% self-pay adjustment. That is what brought it down to $3041.39, which would be the principal after the adjustment.
Okay, and I had 3422.24.
Yes, Your Honor. The 3422.24 includes $380.85 of court costs incurred by the plaintiff.
Oh, that includes the costs. Okay.
And there should be a cost affidavit included with the package. If not,
There is for 380.85, but I didn't realize the 3,400 figure already added that in. If I was looking at your, looks like page 4 of the motion for summary judgment shows that 3,400 figure, and it does not appear that it's got court costs in it. Maybe it does. Oh, I think the 302724 is just the 5th entry on that bill. It's part of what makes up the 11,000. Are you following me? I'm on page 4 of 9 of the summary judgment.
Yes, Your Honor. That is the itemized bill. It actually does have the court costs as well included in there. I think the way that the client makes the adjustment, they adjust the original balance by 65%, the 11,264.40, 65% is taken off of that. And then there's the 380.85 court costs added on top. So at the end of all those adjustments, we get to 3422.24.
Okay, so if a judgment were entered against Ms. Cherry, and by no means have I made that decision, I just wanted to make sure I'm reading the file correctly. The total, the bottom line inclusive of court costs would be that 3,400 figure.
That's correct, Your Honor.
Okay, all right, well, that's a useful clarification. Okay, and I have read the file. I do see Ms. Cherry answered the complaint and essentially indicated that this should have been paid by insurance, and Mr. Biddulph's documents include the denial by the insurance, USAA. And I did want to ask Mr. Biddulph if you're able to explain. It does look like, and hopefully Ms. Cherry has this 9-page summary judgment, so she's following what I'm talking about. But it looked like there were the same charges. It tracked the bill on the prior page, but the explanation is duplicate, and I couldn't understand what that might mean for us.
In full candor, Your Honor, I also don't understand what that means, but I can report. I don't have any personal knowledge of this matter, but my client has reported that USAA has denied the claim because it was a non-emergent medical condition. And we actually did submit further documentation after we received Ms. Cherry's answer, trying to substantiate that it was an emergency procedure, but USAA still held up their denial.
Okay. Well, the one thing the court would, and Ms. Cherry, what today's motion is about is HMA is arguing to the court that they should be entitled to a judgment for that 3,400 figure as a matter of law, meaning there is no controversy here. There are no important facts being disputed. They are owed this money and they should get a judgment for this money. And I just was asking some questions, and Mr. Biddulph, I very much appreciate your candor with the court. I have had an awful lot of cases with HMA, and in a few, there has been a concern whether HMA properly made the request to the insurance company. In other words, the patient saying, look, I have insurance, I did my part, I signed everything, and I left the hospital. HMA, you didn't do it right. If they didn't pay you, that's your problem, not mine. And what I am careful to do before I grant summary judgment is to try to make myself comfortable that it wasn't simply a billing error, a misstep on the part of the hospital, because if Ms. Cherry's right, and I did read her answer, hey, I had insurance, I thought this was done. If she's right about that, I have to make sure that it wasn't simply a back office error. And one thing I noted, which may or may not matter, but this is a date of service of November 2017, and the denial documents are March of 2019. I was worried that perhaps the significant time delay, I don't know if HMA waited all that time to file with USAA, if that made things more difficult to try to get this claim paid, but that was another question that I was concerned about. Mr. Biddle, anything else that you can tell me in that regard?
Let's see, the last correspondence I have from the client was March 17th of this year, where the client advised that they have rebilled and sent medical records and a further explanation of the emergent coding. So from what I can tell, what we have in front of us was not the initial billing. It was after the client had sent further information to try to substantiate that it was an emergency visit. So I can take a quick look here to see if there's anything that shows when it was initially billed.
It sounds like your client, to a certain extent, your client agrees with Ms. Cherry that USAA should pay this claim. They just haven't.
Yes, Your Honor. And also just to further explain with the timing, since these are actually PIP benefits, so they don't have the same timely filing requirements as health insurance. So that's something that does happen a lot with health insurance policies, is that they do have very strict timely filing deadlines. So there has to be a billing within a certain time frame from the date of service. Since this is PIP, there's not as rigid a schedule that they need to have the bill. And also just in my personal experience, USAA is very generous with their deadlines, and they do take good care of their members. So that I don't see any evidence in the file that had anything to do with the denial. The only thing I have in front of me is that it was has to do with USA determining that it's not an emergent medical condition.
Which puts us in kind of a weird spot.
I understand, Your Honor, because one of the charges is an emergency room visit. So I'm not sure if Ms. Cherry has if she's had any correspondence with USAA that might shed any further light on it. I know that members are able to contact their carrier, and usually the carrier is a lot more sympathetic to an argument from the member than they are from the medical provider.
Yep, Ms. Cherry, you're not under oath because I can't see you. Are you able to turn on the camera, hit the little button that says start video? And I could place you under oath, which might be helpful.
So my English isn't good. I don't know if my husband can help me. Question, please.
Oh, there we go. Okay. Good morning, ma'am.
Good morning.
And Ms. Cherry, would you raise your right hand for me? Do you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Would you tell me your name?
Cherry.
Okay. And are you the person that went to the hospital, to the emergency room here?
Yes.
All right. And was that from a car accident or something?
Car accident.
From a car accident. Have you contacted USAA to talk about this lawsuit with the hospital suing you for the bill?
Yes.
What is USAA telling you?
So my English isn't good. I don't know if my husband can help me.
Well, typically I couldn't, but maybe I'm going to be a little bit informal just to see if this will help. Sure, if your husband wants to come sit beside you, maybe he can tell me You're more comfortable with English, sir, is that right?
Basically.
Okay. And so did you talk to USAA about this bill?
Yes, we did. And what we did not understand is the fact that after an accident, someone goes to the hospital, and as a matter of fact, it was not even my wife who recommended that she went to the hospital because she was unconscious. The police, cars of police that were there, it was not one police car. They all called 911, and all of a sudden they put my wife in an ambulance and took her to the hospital. They called me and let me know that my wife got into an accident and she is on the floor. And then as soon as I got there, I didn't even see my wife. They just took her to the hospital. My wife spent, I believe, probably 6 or 7 hours in the hospital. 2 or 3 hours in the hospital. When I got there, I saw her laying in the bed, and then after a couple of hours, they let her go. But what I understand is the fact that they say this was not an accident that should take her to the hospital. I don't understand how it is not, because every accident people have, if it is involved issue, actually as ambulance, they automatically take the person to the hospital if they are unconscious.
Well, have you talked to USAA to make that argument?
To make the argument that the case should not be going to the hospital or not?
That USAA should pay this hospital bill because it was an emergency.
Yes, we did. And USAA said they dealt with the hospital.
I'm sorry, I didn't understand. Can you say that again?
She did, and USAA said they dealt with the hospital.
That they dealt with the hospital?
Yes.
Well, they have not paid the hospital, which is why the hospital is suing you.
Right.
And so what the attorney is saying, and I think he's probably right, is that you may want to call USAA and argue with them as to why they are not paying the hospital, and to see whether you can get them to pay the hospital. Then the hospital will leave you alone.
Okay.
And so, with these things, and again, I'm very appreciative of plaintiff's attorney for helping the court sort of make sure that we are fair about this. I don't know, but it's possible that there's just been a mistake. And it may be the hospital's mistake, or it may be USAA's mistake. But if you want to call USAA and try to push a little bit to see why they are not paying this, because this is what you pay them for.
Definitely.
To cover your costs if you have an accident. Now, it's a lot more complicated, and I'm being very simple, but it's possible that USAA has just made a mistake. And if they were to pay the hospital, then we may be able to make this case go away. Am I overstating that, Mr. Biddulph, or is that accurate?
Yes, that's accurate, Your Honor. I mean, the court costs have been incurred, so that's an additional, that wouldn't be covered by USAA as far as I know. I mean, they may, as I said, they typically do take good care of their members.
Right.
But that would be a slight addition to the balance that the plaintiff is seeking. Okay.
All right. Well, what I'm inclined to do is this. Mr. Biddulph, I'm inclined to deny without prejudice your motion. And that was true even before we talked today, because when we do have these insurance denials, generally speaking for the court, it creates a genuine issue of material fact as to whether that was all done correctly, both by the insurer, which is not even a party, and by the hospital. It is possible, Mr. Biddulph, that with some more legwork, you would be able to establish that to the court's satisfaction and come back and get summary judgment. But in the meantime, perhaps Ms. Cherry can contact USAA and push to see if this is something where there simply has been a mistake. And it may be that the hospital has to put the charge through one more time. I don't know. Mr. Biddulph, is it helpful if Ms. Cherry stays in touch with you, or do you have another piece of advice for how she should communicate to try to figure this out?
I think contacting USAA would be the best way to, the squeaky wheel gets the grease. I feel like if the member contacted them and made it clear that they believe there's some kind of error because it was the charges were directly related to a car accident, I would be shocked that wouldn't clear up the issue, and USAA would need a better reason for the denial than what they've given us so far, which is that it wasn't an emergency.
Well, and Ms. Cherry, did you say you were unconscious initially after the accident? That you were unconscious when you were taken to the hospital? I'm sorry, so you were conscious?
Yes.
Okay, I thought I had heard you say you were unconscious when they took you to the hospital, which would be a pretty good sign that you needed to go to the hospital. And your husband, I don't know your last name.
Cherry. We are both Cherry.
Both Cherry. Okay, Mr. Cherry, did you have something else you wanted to add?
What I meant to say is, when I got there, they already took her to the hospital.
Right.
When she went to the hospital, she was not normal. She was bleeding. She was, a bunch of bruises. And I don't think this was simple for them to say that was not a hospital case. And I myself, I'm not taking my case into this, but I myself was a federal employee working for the Social Security Administration, and a lady ran into my car. They took the lady to the hospital. USA paid all the bill. So when we contact USA and tell them my wife got into the accident, they said to us they are going to deal with the hospital directly. We never got any correspondence later on telling us nothing was done until 3 years later. That would be 2019.
Yeah, it's 2017 is the accident.
Exactly. And 2019, she got the paper saying now she owes $11,000.
Right, and 2020 is when you got a lawsuit. So
exactly.
What I would say is this, Mr. Biddulph, like I said, I will deny the motion without prejudice. If you would like to have a simple order that memorializes that, please submit it. I'll certainly have it in the minutes. And then it may be that if we aren't able to get something that makes this clear as a matter of law, then we just need to set the matter for trial. And see what the evidence ends up being at trial. But either way, it seems to me that we should be able to get this resolved. I'm going to say within maybe the next 90 days or so.
Certainly.
I don't know whether there's any benefit to mediation or whether it really is just something we need to see if we can tag this space. I mean, I can appreciate that Mrs. Cherry may say, look, I don't even want to pay part of the bill if my insurance company should have covered it. But you definitely want to contact your insurance company and make a little bit of noise that you're being sued.
We will definitely do.
Yeah, so we want to make this a priority so that we can get the case resolved for you. Mr. Biddulph, anything else that you would recommend in terms of how the court could facilitate things here?
Perhaps just to keep both parties focused on resolving it, we could schedule a case management conference in 90 days. Prior to that, if plaintiff gets any further correspondence from USA or Mr. and Mrs. Cherry, we could either renew the summary judgment motion or withdraw the case. Hopefully, we can, work it out amicably with having USAA cover the bill.
Okay. Yeah, I think I like that idea. Probably would make it a pretrial conference in about 90 days. And so the sooner, Mrs. Cherry, you can get in touch with USAA to get them to review this claim, hopefully get them to pay this claim, then perhaps the suit goes away. But if USAA is not going to pay the claim, they need to give you some paperwork explaining why they are making that decision. I'm going to give you a new court date that'll be approximately 3 months. And if we haven't made the case go away by then I'll be scheduling the case for a trial shortly after that 90-day pretrial conference. So let me just verify. We've got 4th Avenue Northeast. Is that still a good address for you?
Yes, Your Honor.
And do you also use an email address? Would you prefer that we get everything to you by email, or do you prefer US mail?
US mail.
Okay, so we'll use 4th Avenue Northeast. I will make a note to get what's called a pretrial conference order out to you shortly, which will give you a date, like I said, about 3 months from now. There will be some things that you'll need to do prior to that pretrial conference. So if it's not getting worked out, either by USAA or by some negotiation, then pay attention to that order and make sure that you do what is necessary to prepare for the pretrial conference.
Definitely, and immediately after this conference, we are going to work.
I couldn't quite hear you, Mr. Cherry.
I said definitely, and right after our conference with you today, we are going to work.
Okay, very good, very good. And on the paperwork that you have gotten, the motion for summary judgment, I think, let me just double check. It's got Mr. Biddulph's name and his address and his phone number. So you can stay in touch with him. If, for example, if USAA says, no problem, we're gonna pay it, you can reach out to Mr. Biddulph to let him know or to share information with him, okay?
Definitely.
Mr. Biddulph, anything else from plaintiff?
No, Your Honor, I think we're on track.
All right, like I said, if you want an order, just please submit it to my office. But I'll reflect in the minutes what my ruling was. And then I'll see you all back in a few months. Mrs. Cherry, anything else that I can clarify for you? Okay, all right, well, thank you for your patience this morning. Good luck to both sides. And if we can't get it figured out, I'll see you back in a few months.
Thank you, thank you, Your Honor, and thank you, Mr.
Thank you.
Thanks, everyone.
We'll be in touch.
Okay, court will be in recess.
Thank you, Judge.
Okay, good morning, Mr. Oakey. Welcome to Collier County Court. I'm Judge Martin. How are you doing today?
I'm well, Judge. How are you?
Good. I was just getting minutes filed from a prior hearing. Let me just switch screens here.
Sure.
Okay. All right, and I don't see and have not yet this morning seen Mr. Markley. This is your motion to compel and for sanctions. So it's 11:30. I'll invite you to go ahead and proceed.
Great. The first motion, Your Honor, is the motion to compel. We've had requests for production outstanding since July 27th of 2020. And the court may recall that we came before Your Honor back in January, and Mr. Markley indicated that he had not been receiving his mailings, and he designated for the court an email address in open court, and that was entered into the court's order that all filings would be received to that email address. After that hearing, I emailed Mr. Markley, this would have been back on January 6th, a copy of the request for production, notifying him that they were past due and that he would need to get right on that to get those completed. I then followed up in March, didn't get anything, and then followed up again at the end of April. So we're here for the motion to compel. We're asking the court to enter an order compelling him to complete the request for production. I would ask the court to order that be done within 15 days. I would ask the court for attorney's fees and to reserve on the amount of attorney's fees.
Okay. All right. Well, I believe the motion's well taken. I appreciate the diligence and patience of counsel. Of course, trying a case against a pro se litigant requires a little bit longer fuse, but I think that what you have done here comports with certainly this court's concept of fairness, and at a certain point we have to draw the line, and I think we've reached that point. So I'm going to grant your motion. I will compel Mr. Markley to supply the documents from the RFP, and I would also award you fees for the bringing of this motion, reserve jurisdiction to determine what a fair amount would be on those. Okay, and then you had a separate motion with regard to, I think, the deposition?
That's correct, Your Honor. So I emailed Mr. Markley back in March. I notified him that I wanted to take his deposition. I gave him some dates, asked him to respond. I informed him that if he didn't respond, I was going to set the deposition. Unilaterally, he did not respond. We set the deposition for April 8. He was given notice of that, of the notice of deposition. He did not show up. I'm sorry, the notice was on April 8th. He was supposed to be there April 21st. He did not show up. We attached a certificate of non-appearance to the motion for sanctions. And so I would ask the court to sanction Mr. Markley in the amount, I indicated 1 hour for preparing and attending that deposition, and I would ask for an additional half an hour for the motion and for my appearance today at $300 an hour, so that would be $450. And then the cost of the court reporter was $85, so that puts us at $535 in total that we're asking the court to sanction Mr. Markley.
Okay. I got just a little bit behind you. You said an hour for the deposition in terms of preparation and attendance, and a half hour for the motion and the attendance today.
Correct.
At 300, is that right?
That's correct.
So that would be 450, and then 85 was the cost of the court reporter?
Yes. So that puts us to 535.
Okay. I'm also going to grant that motion. As you know, the court is painfully patient with pro se folks, trying to give them every benefit. But Mr. Markley has been participatory, has been quite competent of navigating these things. He's contributed intelligent conversation and responses, sometimes to the frustration of plaintiff's counsel. But you know, I have little doubt that Mr. Markley is well capable of communicating, scheduling, appearing, and participating. And I think that the $300 fee, the amount being an hour and a half, both are reasonable. And I would grant the motion for sanctions connected to the failure to appear at the deposition, and would award the $450 in fees plus the $85 in costs. So I would ask you to prepare 2 orders, one that grants your compel, giving 15 days, awarding fees and reserving jurisdiction on the amount, and then 2, one that grants your sanctions, as I just recapped, repeating exactly what you had requested. So both granted as requested. I don't think I've edited it at all because I think both requests are reasonable. Is there anything else that plaintiff would ask the court to address this morning?
No, Your Honor, that covers it.
All right. Okay, well, I'll simply ask you to submit orders in Word format. We're not quite getting them from the portal yet, I'm told. So if you want to just email those 2 orders to Ann in Word format, you can copy Mr. Markley. We'll get those executed and filed and served on the parties.
Perfect. Thank you, Your Honor.
All right, thank you. Have a good week.